Welcome to all of you to this webinar on the role of the representative on the child's right to be heard in legal proceedings. I'm Laura Duchamp, legal researcher at the International Commission of Jurists, and I will moderate this event. We are happy and pleased to see you all here. Let me start with a brief, maybe introduction of the International Commission of Jurists. We are a global human rights organization working toward the implementation of international human rights law into national legislation and practices with the goal to ensure access to justice for all and for the most vulnerable. We have been working in the field of the rights of children for many years now, and with our work, we aim today, for instance, to promote the effective realization of children's rights to be heard in and participate in judicial proceedings, so in many different ones, and in line with the Article 12 of the UN Convention of the Right of the Child, but also the Article 3 and the EU strategy on the rights of the child. So we organize this event as part of an EU-funded project. So it's called the Voice Project, Be Seen, Be Heard, Empowering Child Voice in Legal Proceedings, which is a collaborative project with our national partners in 5 EU member states. So today we'll be looking on the role of the child representative in legal proceedings, as I said, and how international and EU legal frameworks ensure the best interest of the child and their right to be heard in these proceedings. And we have some very knowledgeable speakers here with us today. So maybe first, let me just say that after the speakers' presentations, we'll have about 30 minutes for discussions. So please share your question in the chat, and you should have also the opportunity to come in and ask them after the speakers' presentation. So because we have like quite limited time, I will first introduce our first speaker, Nuala Mole. Sorry, there is a Wi-Fi issue. But then, yeah, I was introducing Nuala Mole. She's a senior lawyer and founder of the Advice on Individual Rights in Europe Care Center. So with over 25 years of experience in international human rights law, she has been involved in many cases before the ICJ-EI and the CJU. She will be speaking about the role of the representative introducing the international legal standards and case law. So thank you so much, Nuala, for joining us today, and the floor is yours. Sorry, you're muted. Yeah, maybe can you unmute? Thank you.
Sorry, I thought you had to unmute me. Good afternoon, everyone, and thank you very much to the ICJ for inviting me back to talk again about children's rights in international law and particularly in Europe. What we want to talk about today is the role of the child's representative in judicial proceedings. And I'm going to go rather quickly through the slides, because I think that anybody who's got any questions will be able to ask them at the end of the presentation. So the first and most important thing is Article 3 of the UN Convention on the Rights of the Child, that makes clear that the best interests of the child are to be a primary consideration in any action or omission which affects the child. all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities or legislative bodies, the best interests of the child shall be a primary consideration. And at this point, I should acknowledge that I have adapted, edited, augmented, and deleted some slides that were prepared by Carolina for an event, an in-person event that we had in Brussels last month. You can see that they've got some very beautiful graphics, which are completely beyond my capability. But this is the important thing. The best interests of the child shall be a primary consideration. So the first and foremost role of the child's representative is to make sure that the audience that's being addressed, whether it's a court of law or an administrative decision-making body, that the best interests of the child are a primary consideration and that they mustn't forget that. That's the first and foremost role of the child's representative. And UN General Comment number 14, which is the one where the UN Committee on the Rights of the Child has expressed in some detail the right of the child to have his or her best interest taken as the primary consideration that Article 3 says, notes very clearly that child's interest is a threefold concept: a substantive right, so that means it must be a primary consideration; a fundamental interpretative legal principle, so that means that whenever you are looking at how something needs to be interpreted, you have to look at it through the prism of the child's best interest being the primary consideration; and a rule of procedure which will ensure that in any procedural discussion that takes place, or any discussion about how the rules of procedure should be applied, the child's best interest must always be a primary consideration. So a substantive right, a fundamental interpretative principle, and a rule of procedure. General Comment 14 makes it clear that the evolving capacities of a child must be taken into consideration, with the underlying principle that the more a child knows, has experienced, and understands, the more the child's views can be appropriately taken into consideration. And these are the ways in which a child's best interests need to be taken into consideration: the child's views, the child's identity, preservation of family environment, care, protection and safety, vulnerability, child's right to health, and the child's right to education. These are taken together with Article 12 of the UNCRC, and forgive me if I am repeating stuff that everybody in this webinar knows already, but it never hurts us to think about them again. So Article 12 of the UNCRC is the right of the child to be heard. It is a right and not a duty. That's very important. The child does not have to be heard. So if the child does not want to be heard, then the child does not have to be heard. And that means that you must have child-friendly methods of determining whether or not the child wants to be heard. There are many circumstances in which a child may not want to be heard, and perhaps the most obvious of those is in proceedings where there is a conflict between their parents. They may not want to have their voice raised in that. So that's first and foremost, is it's a right of the child, but not a duty, and the child does not need to be heard if he or she does not want. Article 12 is quite detailed. A child who is capable of forming his or her own views, the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity. The UN Committee on the Rights of the Child, particularly when it's looking at the rights of very young children, has said that most children are capable of forming their views, and the age of the child is key to the weight that you give. The age and maturity of the child is key to the weight that you give those views, not to whether you listen to those views in the first place. And Article 12.2 says the child should be provided with the opportunity to be heard in any judicial or administrative proceedings affecting the child, either directly or through a representative or an appropriate body, in a manner consistent with the procedural rules of national law. And of course, you will recall that if we go back to this essence of Article 3, you will see that a rule of procedure must also be a rule which takes the child's best interests as the starting point. So deciding whether or not a child is going to be heard directly or how they are going to be heard indirectly in a manner consistent with the procedural rules of national law presupposes that the procedural rules of national law are themselves consistent with Article 3. That is, they are themselves, those rules are themselves consistent with the best interests of the child. That's an awful lot to assimilate into one very brief article. Fortunately, we have General Comment 12, which has elaborated on the content of the right to be heard over and above the bare bones that are given in the text of the right. This is an important aspect of the right to be heard. The right to be heard and taken seriously is what the general comment says. The child is to be asked if he or she wants to be heard. And if he or she does want to be heard, they have the right, 1, to be heard, 2, to be listened to. Now just think for a moment in your own languages. I know we have participants from many jurisdictions and many linguistic origins here, about whether you have a word in your, 2 different words in your language, one which is for hearing and the other is for listening. Hearing may talk about just the physical experience of being able to hear something. Being listened to is slightly different. Being listened to is about hearing and then listening in the sense that you are paying attention to what is said and taking it on board. So listening is different from hearing, but both of them have to occur. So the child has to be heard and to be listened to. We had a case once we did in Strasbourg where a child remained separated from her parents for over a year unnecessarily because the person who was interviewing her wasn't listening to what she said, even though they were hearing it, weren't listening to the import of what was being said. Thirdly, the child has to be given a decision which demonstrates that they have been heard and that they've been listened to, so that people have heard what they've said and paid attention and taken seriously what they've said. And finally, of course, to be given reasons for the taking of a decision, particularly if that decision goes against the child's views. So those aspects of the right to be heard and taken seriously are the responsibility of the child's representative. The child's representative must ensure that those rights are given effective recognition. The general comment on Article 12 talks about age limits. We've mentioned that already. So there is a relationship between Article 3 and Article 12. Article 3, best interests, aims to realise the child's best interest. And Article 12 provides the methodology for hearing their views and the inclusion of those views, including in the assessment of best interest. And it's very clear, and the UN Committee on the Rights of the Child has made it clear on innumerable occasions, Article 3.1 cannot be correctly applied if the requirements of Article 12 are not met. You cannot assess and determine a child's best interest as a primary consideration if you have not offered them the opportunity to be heard and then heard them and listened to them. I think we may be going to talk a little later about BJ and PJ against the Czech Republic. This is a very important case, and it's a case where the UNCRC committee in an individual communication said that where the child wishes to express his or her views and that right is fulfilled through a representative, the latter's obligation is to communicate accurately the views of the child. And in those situations where the child's views are in conflict with those of his or her representative, a procedure should be established to allow the child to approach an authority to establish separate representation for the child, for example, a guardian ad litem, if necessary. And that is bringing us to the kernel of the role of the child's representative. And the child's representative, depending on the way in which national procedures operate, the child's representative may have a dual role, one part of which is to put forward the child's views, and the other is to put the child's representatives' assessment and determination of what is in the child's best interest, or there may have to be separate representatives, one assessing best interests and assessing and determining best interests, and another person who is only putting forward the views as expressed by the child. So it's quite complicated. Within the Council of Europe, we have a number of complementary decisions. We have decisions of the European Court of Human Rights. We have the child-friendly justice guidelines. We don't have a lot of time to go into all of those in details today, but what I'm going to look at first is the European Convention on Human Rights. And everybody who looks at the European Convention on Human Rights reads Articles 1 to 18 and the rights which are guaranteed under that. It is absolutely essential, if you are looking at the rights of children, to turn to Article 53. Article 53 says nothing in this convention shall be construed as limiting or derogating from any of the human rights and fundamental freedoms which may be ensured under the laws of any high contracting party or under any other agreement to which it is a party. That's absolutely crucial when you're looking at the rights that children have under the UNCRC, and that the governments will often look strictly at what the provisions of the European Convention say, without saying that other agreements are binding. But if you look at Article 53, you can see that within the convention itself, there is a provision which ensures that constructions of the ECHR must provide at least the same level of human rights protection for children as is guaranteed under other agreements to which the state is a party. And Article 53 applies to EU law, including the EU Charter, and to the UNCRC. EU law, obviously, only in countries that are member states of the EU. But very often, the court seems to adopt an approach which is introducing the relevant EU law or the relevant provisions of the UNCRC as though they were just provisions of comparative international law, without bearing in mind the provisions of Article 53, which say that they may not construe convention rights in a way that limits or derogates from the rights which are included in any of the other provisions. So, the best interests of the child principle and the child's right to be heard are not expressly found in the ECHR, but the European Court of Human Rights approach has evolved to reflect those. Back in 2003, in a case called Sahin and Germany, the court said it would be going too far to say that domestic courts are always required to hear a child in court. But this issue depends on the specifics of each case, having due regard to the age and maturity of the child concerned. That's 2003. Then we move on to 2005, and we have the case of M&M and Croatia. Paragraph 181 of that judgment said, it cannot be said that the children capable of forming their own views were sufficiently involved in the decision-making process if they were not provided with the opportunity to be heard and to express their views. So that's 2 years after Sahin and Germany. Then we move on 10 years on to NTS and Georgia, where the court said, taking into account the relevant international standards, the court does not understand why the domestic courts failed both to give any consideration to the possibility of directly involving the older boy in the proceedings and to give reasons for not hearing him. The potential need for his direct involvement was particularly apparent given the flaws in the quality of the boy's representation. So here we have a rebuke clearly delivered by the court to the representation of the children in the NTS and Georgia case. Very important because it tells us that the children's representative were the ones who needed to be insisting that the children were heard and properly involved in the proceedings. And we have now another case against Georgia, which has been communicated to the government and which is pending. Two applicants, a mother in her own right and also representing her son, aged 12, complain under Articles 6, 8, and 14 of the Convention about the outcome and length of the relevant proceedings. They allege that the domestic courts failed to properly assess the second applicant, that's the child's, best interest when permitting the father to take him to Canada for a visit. The court has asked if the child was able to express his views in the domestic proceedings. This case is still pending, and I should, in the interests of disclosure, point out that the Air Centre has intervened as a third party in this case, setting out more or less what I'm discussing with you today. Jeunesse in the Netherlands was a grand chamber judgment back in 2014. The court reiterates there's a broad consensus to support the idea that in all decisions concerning children, their best interests are of paramount importance. Oh dear, here we get the introduction of paramount, whereas what Article 3 of the UN Convention on the Rights of the Child talks about is primary. And sometimes this causes problems because of translation. Sometimes it's not. Sometimes, for example, into French, they translate both paramount and primary as primordial. In English, paramount and primary mean different things. Primary means that it is a consideration which is more important than many of the other considerations and should be recognized as having that importance. That's a primary consideration. And paramount means that it can trump, it can be the decisive consideration. In the UN Convention on the Rights of the Child, Article 3 only talks about the child's best interests as a primary consideration. The only place in the UN Convention on the Rights of the Child that the best interests of the child are considered to be of paramount importance is in Article 21 about adoptions. However, the European Court of Human Rights, not just in Jeunesse, but in many cases since then, has rather loosely used the word paramount in circumstances where they may have meant to say primary. But that's an important thing for us to be aware. In Strasbourg, you can probably order that the best, or you can probably argue that the best interests of children are of paramount importance. But before the UNCRC, the only place where the best interests are of paramount importance is under Article 21 and in adoption cases. Children's representation before the ECHR. Children are normally represented by a parent or parents who have not been wholly deprived of parental rights. It's a very complex and difficult tapestry of jurisprudence surrounding this, because sometimes parents who have been deprived of parental rights are allowed to represent the child if their complaint is that they were deprived of parental rights. And sometimes parents who have been deprived of parental rights are not allowed to represent the child because the court says that they don't have the right to speak for the child. This is an ongoing roundabout of discussion. However, one thing is emerging clearly now, which is that where there is a suspected conflict of interest between the parent who is purporting to represent the child, the court may decide that the child needs separate representation. And this was the case in A and B and Croatia, and again in AP and AM and the Czech Republic, because the court, the Strasbourg court, decided that the parent who was representing the child or putting themselves forward as representing the child was really only representing that parent's interests and not the child's best interest.
Hi, Nuala, just jumping, just watching the time, so that if you can, just to make your...
Can I have 3 minutes?
Yeah, sure.
Thank you. Okay, so we see the guidelines of the Committee of Ministers of the Council of Europe on Child-Friendly Justice, who have set out very complex and important procedural safeguards to ensure that children are properly participating in proceedings affecting them. And you can all look at the guidelines of the Committee of Child-Friendly Justice in your own time. Let's move on now to EU law. As a matter of EU law, under the Charter of Fundamental Rights, Article 24 of the Charter says, and it's sort of paraphrasing the wording of the UN Convention on the Rights of the Child, but of course, whenever anybody paraphrases anything, they leave it open to having a different interpretation from the interpretation that's given to the well-known views. So as you can see there, you don't need me to read it out, the Charter of Fundamental Rights, but this means that the provisions of the UN Convention on the Rights of the Child, as reflected in Article 24 of the Charter, are applicable as a matter of EU law in any situation where EU law applies. And that's very important because obviously there are aspects to EU law which are different from the way in which the UN Convention on the Rights of the Child or ordinary domestic law apply. I couldn't do anything about making this font come up at a size that anybody can read it, but you can see that there is the case 6323 Sagrario Joaquin and Prudencia of the 12th of September last year, which is very important because it's building on the jurisprudence of the Aguirre and Zaraga decision from 2010. It's not so much that the Charter requires that a child must be heard, but the child must have the opportunity to be heard, and that's very important. I'm not going to try and read the tiny little font that's got the quote from Aguirre Zaraga, but this is what I think is best. The right of the child to be heard does not necessarily require a hearing, but it does require that the procedures and legal conditions be in place to enable the child to express his or her views freely, and that those views are taken into account. And this is a principle that applies to any aspect of EU law. So it can be asylum determination, it can be reception conditions, it can be detention, it can be any sort of taking into public care, which is regulated by EU law because it has a cross-border element. It can be child abduction. It can be children's rights in criminal procedure, whatever. But it's very important that the child must have the opportunity to be heard. And we can all think of many circumstances, particularly in immigration and asylum, where the affected children are not heard. Concluding thoughts. The role of the representative can be important in best interests assessment and determination if in national procedural law the idea is that the child's representative should make the assessment and determination of what's in the child's best interest and then present that to the decision-making body. But the second role, which may require a different representative, is ensuring that the views of the child are accurately heard, listened to, and presented to the decision maker. Thank you. And thank you, Laura, for your patience.
No problem. Thank you a lot for presenting very well and really shortly the international framework. So for this region, I just recall that we'll have a dedicated time for question at the end of this webinar, but we are moving forward already because we're a bit rushing of time on the second session of the webinar, which is going to focus on the BG and PG versus the Czech Republic case before the UNCRC that Nuala already mentioned. So with Anna Sležková, who is a lawyer specializing in child rights and the protection of vulnerable groups at Forum for Women Rights based in the Czech Republic. So maybe Nuala, if you can stop sharing your screen so we can display Anna's presentation. So with some concrete example from this case presented by Anna, we'll then be able to move to your presentation. Nuala, do you manage to stop sharing your screen? Yes, thank you. Great.
I may try to share once again because I think where the problem might be. So I will try to share if you will see my.
Yeah, sure.
So can you see my presentation?
Yes,
so
we can.
Okay. So now it's okay. I can see it as well. So thank you for the floor. I will try to be on time and I will try to give a brief presentation of a case we represented or litigated before the UN Committee on the Rights of the Child on behalf of the authors who were children age 30. But it's not. Here. Okay, it's moving. Okay, so two children at the age of 13 and 16 years old at the relevant time who were placed or in an alternative care institution against their will and wishes. The reason was that there were some problems with school attendance concerning the younger girl and lazy way of living concerning the older boy because the boy had already completed the obligatory school attendance. So this was not the problem, but he was not working, not attending secondary school. And concerning both children, there was suspicion that there might be developing some social phobia in them. So I would like to mention that we do not underestimate the seriousness of these concerns, but what we challenged, what we questioned was that the solution was a coercive measure applied on children. and the placement took place on basis of an order issued by the appellate court, and this is very important because the measure was proposed by Child Protection Authority, but the Court of First Instance rejected to adopt this measure. The Court of First Instance said that there are problems concerning these children, but this is not a solution, and it would only worsen the whole situation. But there were appeals against this decision from public prosecutor and also from the procedural representative of children seeking their placement in the institution. So the child's procedural representative, the guardian, submitted the appeal against the will of the represented children, and this is what we found to be a problem. What we found to be a problem. Sorry, my son just came. No, Miri, take ne. Sorry, Mom. Sorry. Before entering into details of our arguments, I would say two brief information about the system in the Czech Republic, the system of procedural representation of children in care proceedings concerning proceedings on children's removal from their family. And the whole system is set that children cannot be represented in these proceedings by their parents. We presume that there's a conflict of interest and children can never be represented by their parents. They have to be appointed a special procedural representative who has the status of the guardian. It is the guardian, and preferably the guardian should be the Child Protection Authority. Child protection authorities in Czech Republic have two major tasks. The biggest task and the major load of their work is to ensure public protection of children in situation of social danger. In this role, they act as administrative authority and they represent the state's views of what's in the best interest of the child. But the second role should be to be the procedural representative of the child in legal proceedings, especially in proceedings concerning care measures or other measures concerning the development of children.
May I just jump in? We cannot see the slide. I don't know if you changed them, but we cannot see the different one.
You still see the first one?
Yes, exactly. Just for you to know. I mean,
and now?
we can still only the first one. Sorry.
Okay, so I will stop sharing. Yeah, there's some. Yeah, I will stop.
Yeah, maybe if you can just click on
I will
the
stop sharing
left
if I
side.
ask you to share it for me because I thought it works, but it doesn't work.
Yeah, we'll do it. Sorry for this. You can continue and we'll upload it. Sorry.
Okay.
I can try to share it if that's okay.
And the second remark I would like to mention that and what we and the issue we try to open in the proceedings before the UN Committee on the Rights of the Child is the problematic role of the guardian ad litem, because the question we asked was if the guardian should act in the proceedings according to the best interest of the child or according to the child's views. And we concentrated especially on the issue of the exercise of the child's procedural rights, because in the case, the children's procedural rights were exercised against the will of their children to get a solution that was against their will and wishes. And we try to argue that if the procedural guardian acts in the best interest of the child, this may move away from the perspective or the concept of procedural accommodations which are necessary to enable the child to exercise their procedural rights on an equal basis with others. Because the guardian's actions may, in this case, in turn impair the child's procedural position and access to their procedural rights, what happened in this case. And it may make the guardian to be rather an assistant to the court in determining the best interest of the child than to the child in exercising the child's procedural rights. And if we look at this question, at this issue from the disability rights perspective, we can see that the UN Committee on the Rights of the Persons of on the rights of persons with disabilities is very worried about the concept of the best interest of the child to be of the best interests. Sorry, not of the child, but the best interest to be applied on adults with disabilities, because it sees that it may create space for substitute decision making, and substitute decision making, including guardianship, is something that undermines equality before the law. And these were our arguments. May I ask for the next slide? Yeah, these were our arguments in the case. We try to argue for the adoption of the perspective of procedural accommodations and to determine the role of the child procedural representative as someone who should support the child in the exercise of the children's procedural rights, and to compensate the child's vulnerability concerning the exercise of their procedural rights. So we try to argue that guardian should be someone, the procedural representative. In the case of the Czech Republic, the guardian ad litem should be someone whose task is to ensure the procedural equality of the child. And this should be especially true in proceedings where the best interest is hardly objectifiable, which is especially proceedings concerning the child's living arrangement, including care proceedings, because it's very difficult to objectify the best interest of the child in these issues. There are always subjective beliefs, what's the best for the child, but what's really objective. This is very hard to say. And this does not mean that we would deny the importance of the best interest of the child, but we try to present our arguments that it is the court who should guard the best interest of the child in the proceedings, not the child's procedural representative, because neither the procedural representatives of other participants are asked to guard the best interests of the person they represent. They act according to the views of the represented person. So why the child should be in worse procedural position? The adopted views of the UN Committee on the Rights of the Child, they were slightly mentioned by Nuala in the previous presentation, but I must say that we find these findings and recommendations a little bit confusing and a little bit disappointing, because they really did not answer the question we wanted to be answered. They did not help, in our view, to determine the role of the procedural representative, the guardian, concerning the child's access to the child's procedural rights. In the part of the views concerning findings, there are especially two arguments which may not be sufficient to really answer the question we raised. The first argument is that the committee said that if there is a conflict of views between the child and their guardian ad litem, the child should be appointed a separate representative. But there's a very big but. The guardian still remains in the proceedings. So the question, is the guardian allowed to exercise the child's procedural rights contrary to the will of the child? For instance, to appeal against the will of the child, against a decision the child is satisfied with. So can the guardian do it? This finding does not really answer this question. And the second argument made by the UN committee was that given their ages, the authors should have been given the opportunity to be heard directly by the court. But again, to be heard is maybe something different than to have the opportunity to exercise my procedural rights. And especially, it is not the same as to have the right that my procedural rights are not exercised against my will. And concerning recommendations, and this is where there's a slight confusion, recommendations may concentrate it on a completely different issue that we did not really mention in our submission in the communication, and they recommended the Czech Republic to ensure that the child always has appropriate legal representation during the proceedings. The child should be provided with a legal representative in addition to guardian or representative or his or her view, where there is a potential conflict between the parties in the decision. And I must say that, again, we find the access to lawyer and to legal representation very important, but this was not the point we concentrated on in our submission. This was not the question we really asked to be answered by the UN Committee on the Rights of the Child. I think that there may be a little bit confusion because again, here the committee, it's from the general comment, it's a recommendation which copies the general comment number 14, and the little confusion that which is there is that the committee mentions that there's a legal representative in addition to guardian or representative or his or her views. So who is the child's representative or his or her views? It is the guardian or it is the second person, and should there be a lawyer as a third person? So this we find a little bit confusing. And the second remark I would like to make on account of this recommendation is that the legal representation does not necessarily have to be appropriate procedure accommodation, because even the lawyer may be asked by the national legislation to act in the child's best interests instead of according to the child's views. I have a concrete example from Czech Republic, where until recent amendment to Juvenile Justice Act, children below the age of criminal responsibility were obligatory represented by a lawyer, but the lawyer was not had not the status of defense counsel or similar to defense counsel, but he was the guardian, and it was really highlighted that he or she should act in the child's best interest, not as a traditional defense counsel in criminal proceedings. So this may not really be the answer to the problem which was central to this case. So my conclusion would, on the account of this case and on these views of the UN Committee on the Rights of the Child, would be that the UN Committee on the Rights of the Child did not sufficiently pay attention to the dimension of equal opportunity to exercise of children's procedural rights in the proceedings concerning them as an integral part of the child's rights to access to justice. And again, if we look at the problem from the disability rights perspective, then the UN Convention on the Rights of the Persons with Disabilities is based on the rule that the vulnerable situation of the person should never reduce the opportunity to exercise all human rights on an equal basis with others. So if we mention all human rights, this includes also procedural rights. And the question we should ask is why the child should have lower opportunity to exercise their procedural rights in proceedings concerning them on an equal basis with other participants, if it is the court who should guard the best interests of the child. So thank you very much for your attention, and I would like to apologize for the interruption and for the problems with the presentation, and also for my English. So
no, really, thank you for your presentation, and it's okay. We had some technical issues, so we're a bit running out of time, but that's okay. I mean, thank you for your practical example, and your insight could lead the audience to consider litigating before the CRC committee one day. And before I open the floor to question, we have a third session of this seminar focusing on the child's right to be heard, but focusing on the EU law perspective. So I'm pleased to giving the floor to Laura Stelzer, who is working as a legal and policy officer at the DigiJust of the European Commission. Sorry, I'm stopping sharing my presentation so you can display yours. And she's working in the criminal procedural law unit. So please go ahead.
Yes, hello everyone, and thank you very much for the invitation. to be part of this webinar today and to speak to you a bit about EU law and the child's right to be heard in it. I'll just briefly share my presentation as well. Right, I hope you can all see it now.
Yes, thanks.
Then to jump right in, we have already heard quite a lot about the rights of the child under international law. We have heard that the child has a right to be heard, to be protected, and to be treated with dignity, and that these are fundamental and human rights which are enshrined in Article 24 of the EU Charter, as well as in the UN Convention on the Rights of the Child. And of course, we have heard that the child's best interest must always be a primary consideration. What this translates into at the EU level is a requirement for child-friendly justice systems to be established with very specific safeguards for children in legal proceedings. So there, I would say, are two levels to what the EU is doing in this regard. There's a strategic level, which encompasses the EU's commitment to promoting child-friendly justice as reflected in the EU strategy on the rights of the child. The strategy emphasizes access to justice, capacity building for legal professionals, and participation of children in shaping justice systems. And linked to this is also the EU's Children's Participation Platform, where children have the possibility to voice their concerns and views on matters of EU policy. Then, on the other side, we have a legal level, where the requirements of the Charter and the UNCRC have been translated into a variety of legal instruments and soft law measures that span administrative, civil, and criminal matters. The latest measure to have been adopted is the Interdisciplinary 2024 recommendation on integrated child protection systems, which is, however, a non-binding instrument. So binding rules on the rights of children in legal proceedings, including the right to be heard, are set out in sector-specific instruments. I today will only be speaking about civil law and criminal law, as those are the areas that fall within the remit of my DG, so DG Just. I will not be speaking about migration issues, but of course, we should keep in mind that there also is a very relevant EU law in that respect. So I will start with civil law. In civil law, the EU has competence to adopt rules on matters of cross-border cooperation. And a very prominent example, which I'm sure you're all familiar with, is the 2019 Brussels 2B regulation, which is a cornerstone of EU judicial cooperation in matrimonial matters and matters of parental responsibility. The opportunity of the child to express their views freely plays a very important role in the application of this regulation, as in principle, a child who is capable of forming his or her own views must have a genuine and effective opportunity to do so, either directly or through a representative or another appropriate body. Now, this applies both in the context of proceedings regarding custody and access rights, as well as in proceedings regarding return of children who have been adopted by one of their parents. When assessing the best interests of the child, due weight must then be given to the views as expressed by the child. What the regulation does not do, and what it leaves open, is the question of who will hear the child and how the child is to be heard. It leaves this to the procedural autonomy of the member states. And it also does not prescribe a procedure for how to establish the capabilities or capacity of the child to form their own views. What this means in practice is that member states can, for instance, choose whether a child should be heard by a judge or a person that is specifically trained to do so and heard by them, and later on the views reported to the court, or, for instance, whether the child should be heard in the courtroom or in another place or through other means. It also means that the right of the child to be heard is not absolute, but must be assessed taking into account the child's best interests, for example, in cases involving agreements between the parties, for instance, in custody disputes. There is some very interesting case law by the Court of Justice, specifically on appropriate arrangements that are to be put in place by courts when they hear children under the regulation. For reasons of time, I've not included an overview here, but happy to provide some references later on. Then if we move from civil law to criminal law, we are in a bit of a different situation. So in EU criminal law, we are competent to adopt rules both for judicial cooperation and general minimum standards for the rights of individuals in criminal procedure. What that means is that in the area of EU criminal law, the EU has adopted much more precise rules on the procedural rights and safeguards for children. The main two instruments, and I'm sure you are familiar with those as well, are the Victims' Rights Directive and the 2016 Procedural Safeguards Directive for children who are suspects or accused persons in criminal proceedings. These directives provide what one might call a very comprehensive framework to ensure that children can effectively participate in proceedings and, very importantly, can effectively exercise their right to be heard. The basic principles are very much the same for both instruments. Both the Victims' Rights Directive and the Procedural Safeguards Directive establish a requirement for the child's best interests to be a primary consideration in line with the UNCRC. And this is very, very important for both instruments, for the child's individual circumstances, needs, and vulnerabilities to be assessed and taken into account throughout any decision taken vis-à-vis the child throughout the proceedings. Both instruments also provide, of course, for the right of the child to be heard, and both provide for the child's holders of parental responsibility or another legal representative or another appropriate adult, as we speak of in the Procedural Rights Directive, chosen by the child to be informed and involved in the proceedings to support the child in exercising their rights. More specifically, when we speak about victims, child victims to be heard, the authorities must take due account, of course, of the child's age and maturity, but the child's age itself cannot serve as an excuse not to hear the child at all. The child victims also do not only have a simple right to be heard, but they have a right to understand and to be understood. And that means that communication with the child should be conducted in a child-friendly manner, but also that the child is given every opportunity to express their views and to have those views understood by the other participants to the proceedings. Where there is special cause for protective measures, of course, child victims' testimony can also be video recorded. So this allows for the child to be heard while minimizing the risk of further trauma through direct contact with the suspect or accused person. And as I've already mentioned, to support child victims in exercising their rights, the child can be accompanied by a holder of parental responsibility, or what in the Victims' Rights Directive is called a formally appointed special representative. This can be a representative of the child protection authorities, for instance,
Yes,
in
sorry,
that
I'm just
regard.
jumping in as well. Same, we don't have the slides of your presentation. We still in the civil matters. Sorry. Yeah.
There we go.
Oh, yes.
That was my bad. I forgot about that.
No
Thank you very
problem.
much for reminding me. Right, then now that we have my criminal law slide, which is very extensive, I know, I would move on to suspects and accused persons. So for children who are suspects or accused persons, we have, as I mentioned before, the Procedural Safeguards Directive. And that generally obliges member states to ensure that children have the right to be present at their trial and to take all necessary measures to enable them to participate effectively, which includes giving them the opportunity to be heard and to express their views. Now, this implies that member states should provide incentives for children to attend their trial, including by summoning them in person or by sending a copy to the holders of parental responsibility. But member states should also make practical arrangements to ensure that the child is present at the trial and shall set out the specific condition under which a child can temporarily be excluded from the trial without, of course, prejudicing the child's right to be heard in some fashion. As for child victims, children who are suspects or accused persons have a right to be accompanied by their holder of parental responsibility, or, and here we talk about a concept that was newly introduced in this directive, another appropriate adult that is chosen by the child. That can be a person of trust to the child, it can be a teacher, it can also be a representative of a child protection authority. And here comes the difference between the Victims' Rights Directive and the Procedural Safeguards Directive. Namely, the Victims' Rights Directive does not regulate under which circumstances children are entitled to a lawyer, whereas the Procedural Safeguards Directive sets out very clear rules on mandatory legal assistance. So under the Procedural Safeguards Directive, EU law directly guarantees the presence of, first, a holder of parental responsibility or another appropriate adult, at least during the trial stage, and of a lawyer. Last but not least, and I think this is very important to mention as well, is that the directive includes a requirement for all relevant legal professionals and that are in contact with the child throughout the proceedings to receive or at least to have access to specific training to properly implement and apply all of the rights that I've already spoken about. Of course, the staff that is supposed to apply them, supposed to ensure the effective exercise of these rights, needs to have specific training to a level appropriate to their contact with the child as regards questioning techniques, child psychology, and communication in a child-friendly manner. And this is meant to be ensured for law enforcement authorities, staff of detention facilities, judges, prosecutors, lawyers, and any and all staff that work in the vicinity of or connected to these proceedings, such as also probation staff. Now, the bottom line is that member states still have a degree of procedural autonomy in terms of what precise measures they take to ensure the rights as set out in the Victims' Rights Directive and the Procedural Safeguards Directive. But the acquis that we have is precise enough, or has been so far reported to have presented a big step forward in ensuring that children have the effective possibility of exercising their right to be heard in principle. Of course, there are always cases in which justice systems do not work as they are supposed to. And there are also cases in which there are systematic shortcomings. And this is where we come to the enforcement stage of the EU policy cycle, so to speak. We are constantly monitoring, of course, compliance with our legal instruments and their application in the case of regulations across the member states. And I am sure that you're all aware of the infringement proceedings that the Commission can launch to ensure that EU law is transposed and applied effectively. And we do have at the moment quite a number of open cases, in particular concerning the Procedural Safeguards Directive, where we are in dialogue with member states to ensure that the directive is completely transposed. And at the same time, we are revising existing rules where, in the context of developments over time, a need for further improvement is seen. And this is, for instance, the case with regards to the Victims' Rights Directive, where the Commission adopted a proposal for a revision in 2023. This proposal is currently under negotiations. But we can already say that the main aim is to ensure better protection, including for vulnerable victims, such as children. And in this way, the Commission is constantly working towards filling possible remaining gaps, as well as supporting, and this is important, this is not only a punitive measure, but we're trying to support member states in ensuring that they correctly implement EU law so that children are protected and safeguarded in practice. And on this note, I would hand the floor back to Laura. Thank you very much for your attention.
Thank you to you for this EU framework. It was really useful for us, I think, for all the legal practitioners attending here today. So I will not wait for opening the floor to comments. We have approximately 20 minutes. So I invite you to raise your hand, and you can then quickly present yourself and make your comment or ask your question directed to one of the speakers or to the audience. You can also share them in the chat. So yeah, we are welcoming any question we may have from you all. Yes, Carolina, go ahead.
Hi everyone, and thank you all for the presentations. It was really interesting. I'm Karolina Babicka from the International Commission of Jurists, and I would actually just have a follow-up question to Laura, that you just actually, after you presented this detailed and quite robust legal framework of the EU legislation, you also mentioned the enforcement and monitoring and infringement proceedings. So I think it would be interesting to hear your advice, perhaps for lawyers or NGOs, who some of them may be in this webinar, and they may come across some either incorrect legislation or incorrect application of legislation by EU member states regarding procedural rights or the right to be heard of children in legal proceedings. So what would be your advice on potentially approaching the Commission and kind of alerting you about these issues? Thank you.
Right, thank you very much for that very important question, because this is indeed a key factor. We are, to a large extent, when it comes in particular to the application of EU law, relying on practitioners signaling where the application is incorrect on a systematic level. So where we cannot take action is where there is an incorrect application of EU law in an individual case. This is important to know in general, although it should not keep anyone, of course, from submitting a complaint. If we receive 200 complaints on the same issue, obviously we will also see that there is a systematic problem. But in particular, when it comes to lawyers, oftentimes they have a better overview of a number of cases in which a similar issue has arisen. If that is the case, then it is very useful if, when you contact the Commission, you point this out immediately, so that we have a better understanding of the context in which, for instance, a particular case that one lawyer has been working on has occurred. When it comes to issues in terms of transposition, so issues in law, we do always conduct our compliance assessments at the end of the transposition phase for our EU legal acts. Of course, there are then legal developments. Some of our directives, for instance, the directive on the right to information is from 2012. Since then, a lot of criminal procedural codes have been revised in various fashions, and our compliance assessment that we did at the time might no longer be accurate. Then it is also very useful if you consider, for instance, that there is a legal development that brings national law out of compliance with EU law, to notify this to us, and then we will check it and either start a pilot dialogue with the member state concerned, or we will start an infringement procedure. And maybe just to recall briefly that there are 3 different types of infringement procedures that we do launch. One is non-communication, which is basically happens at the very beginning of transposition and is not usually something that that comes up later. The more interesting ones for practitioners would be the non-conformity, so where law incorrectly transposes EU law, or bad application, where there's a systematic issue of the authorities of a member state not applying EU law or national law that has transposed EU law correctly. I hope that answers the question.
Thank you. So does anyone else want to jump in and raise a question or add any comments? If you want to mention your work. Yes, go ahead.
I should like
speaking, but yes, go ahead.
I should like a question, if I may.
Yeah, sure.
Well, I'm Erik van der Musselen. I'm a Belgian lawyer. I'm not of the one of the 5 countries involved, but it was interesting to listen to Laura, because I had already, in the 48 years that I'm working in youth law, and I'm a practicing lawyer in Antwerp, 2 times the temptation to go to the commission. But there is a question always that rises. If you try to defend these minors, they are 12 or 14 or 16 years old. If you start a procedure, you have need for a mandate of these minors. In Belgium, minors are party in the youth procedure as well in criminal as in protective procedures. They are individually capable to go in appeal with their mandatory lawyer, and I'm always a mandatory lawyer. And if we once were appointed, for example, in a protection case, children are 1 year old, not cared by the parents, we will, the next 18 years, always be appointed for new problems. So we know these minors very well. The problem is when a minor passed a procedure, for example, a criminal procedure, and it ended, he goes back home, he's not interested anymore to go to wherever with that case. They do not like to go in appeal, in cassation, in the human rights court, etc. So I ask myself, if you like to prove structural problems or systematic problems, and I think we can, do we need for 100 or 200 cases the mandate of these minors or their parents to go to the commission? That is my question.
Thank you for this question, which is, of course, an interesting one, and one which actually no one has ever asked us before. But the way that you can approach the Commission to point out issues in the application implementation of EU law is by filing a complaint. You can file that complaint and point out the issue on your own behalf, simply stating that you are a lawyer that has acted in a case.
Yeah.
You do not have to act for the child. You can point out if you are aware of an issue, because it's not that you are entering legal proceedings with the Commission. It would be the Commission which would, if we see a systematic issue, would open infringement proceedings against the member state. And that does not necessarily have to involve any of the complainants. So in principle, you can point out an issue if you are aware yourself. The question is, when there is follow-up, when we have a dialogue with the member state, whether there at some point is a need to speak about the persons directly affected, but that is something that will come way later in the procedure. So at the initial stages, you can file a complaint yourself.
For example, 2 years ago, I gathered 174 decisions of the youth court with provisional measures against minors without a lawyer having been asked before the judge. I sent a note to my colleagues in Antwerp, and in 3 months we had 174 of these, in my opinion, illegal procedures, because the minor and the lawyer were not heard and not asked to come to the court. Today we have several procedures. We have new legislation. 12 to 14 years old can be put in a detention for 2 years. 14 to 16 years old can be for 5 years in detention, and 16, 17 years old can be put 7 years in detention. There is a special procedure. I went in appeal for a boy, and I met 2 other colleagues who did the same thing. And we saw and we heard that the prosecutor's office tried to convince the institution where the minor was present to give him the advice to declare that no appeal was needed. In my case, I had spoken to the minor, we agreed about the appeal procedure. So, and we see that our counterparty, the prosecutor, tries to get his information to and his advice to the minor not to go in appeal. That was already 3 times the last 4 weeks. I'm sure that there will be more, and that is a kind of acting that is not allowed, of course. Perhaps we can make also from that kind of procedure an example for the prosecutor's office, for the judges. But I understand I can do it with my colleagues, gathering some decisions, making a kind of communication for the Commission that it concerns a structural problem, and then the Commission will see if it is possible to take it over and to start the work against the Belgian state.
Yes, if you do make a complaint, or just to add, it is vitally important that you make it clear what EU law, what provision of EU law you believe has been violated. Because that is often the problem when we receive complaints and it's not clear where exactly the problem lies. So this is something very important to keep in mind.
Okay, good. But the minor has to be heard. If they do not hear him, and even not his lawyer, then I think there is a big problem. Also,
this is quite a big issue. Indeed, I agree. I hope this will be going further and this help with your litigation. Maybe we can just, because we're running out of time, so just to collect other questions. I can see that Saxon raised your hand. I don't know if it's the same topic or if you go ahead, please.
Thank you. My name is Helmut from the Boltzmann Institute of Human Rights in Vienna. And thanks for the presentations. Good to see the speakers here. I have a question, one step further, so to say, when it comes to representation of children, because it's actually about participation, and it's actually also about communication, and communication is 2 ways. And I wonder about the qualification of legal professionals, including judges, to actually hear children and listen to children adequately. I'm not sure if there's any kind of a mandatory legal provision in all of these documents, which actually requests such a competence, some specific legal training, which I see some kind of a missing link. Because in order to understand perhaps even these different roles of a representative being a person just giving a voice to a child, or actually doing an assessment, to understand that kind of different roles, and also the practical things, how to deal with a child in front of a court. At least in Austria, we have a big discussion, or a big problem actually, that we do not have mandatory legal training from asylum cases to sometimes even for family courts. There is no specific mandatory training on certain aspects of child protection foreseen there. So I wonder, all our focus on representation of the child, I think we also need to take into account the perspective of the other side, thinking of the Laura model, for example, where you also have voice on the one hand, but you also have to prepare the audience. In this context, the courts, prosecutors, judges. And I wonder if we have any kind of mandatory legal provision to actually ask for that kind of qualification of judges. I'm not aware of such a requirement actually. And it's always difficult to ask judges to get some training because of independence, etc. Thank you.
I don't know if, again, Laura, do you want to jump in regarding the EU framework or?
Sure, I can do that. But I think your last sentence, Helmut, was already very telling. Judicial independence is the key word. So we do have in the directive on procedural safeguards for children, we do have a provision in Article 20 that reads that member states shall ensure or shall take appropriate measures to ensure that judges and prosecutors receive training, for instance, in child psychology and children's rights. Now, what taking appropriate measures means is important. It's not the same as ensuring that they receive such training, because we cannot interfere to that extent with judicial independence, and that includes the training of judges. So what member states must do is they must take measures such as by providing funding, by making it a political priority, pushing for such training to be provided, by training academies for judges, but they cannot oblige such academies to provide this kind of training. And that is where a bit of the issue lies, that the limit to which we can legislate to ensure that such training actually takes place.
Thank you.
But we do have lots of funding.
Mm-hmm.
I just want to say there is judicial training for the judiciary, for judges, for prosecutors, that is being offered on the implementation application of EU law. So that at least we can provide.
Thank you. Maybe can I take the question of Aisha? You raised your hand. I don't know if you're still in EMEA, or if you want to. Yeah. Yes. Okay. No, I cannot. We cannot hear you, Aisha. I don't know if. Maybe in between the time you unmute yourself, I can take the comment from Nuala. Go ahead.
Thank you very much. I was just thinking, in answer to Helmut's very pertinent question about have we got any binding requirement that those who provide assistance and representation to children, there is no international binding requirement, but that's because governments haven't sought to adopt such an international binding requirement. And of course, this requires money. In England and Wales, it's different in Scotland and Northern Ireland. In England and Wales, a judge cannot hear cases involving private children in private family law unless he or she, the judge, has gone through a mandatory training and got a certificate to show that they have completed that training, and then that they have to practice as a private family judge before they can then apply to be a public family judge, that is a judge with the power to take children away from their homes. And I think that that's something which is always rather carefully looked at. And in child protection proceedings, the child has his or her own lawyer. And I think this goes back to what Anna was talking about in the Czech case earlier. The child has his or her own lawyer, but the Child Protection Authority is separately represented in the proceedings. And we have had a number of cases in Strasbourg, which we have successfully argued on behalf of children, where the Child Protection Authority and the child's lawyer had diametrically opposite positions, but the Child Protection Authority was successful in the litigation. So there are a whole lot. It's a bit like walking into one of those halls of mirrors at a fun fair. Every time you take a step forward, the mirrors reflect a different picture. But thank you to Helmut for bringing up that very important point about training and understanding, because we know from the feedback that we get from the children that they have very mixed experiences of the adults who are supposed to be the professionals who are supposed to be representing or helping them. Thank you. Sorry, that was a bit long.
No, that was so really, insightful. So I don't know if Aisha want to jump in still or not. Otherwise, I think we can have a last question from Eric. Yes. Sorry, you're muted. Yes, go ahead.
Yeah, it's better.
Yes,
Yeah?
yes.
You hear me? Okay.
Yeah.
I would only ask in a matter of training that since 20 years, the candidate lawyers who like to be a youth lawyer in Flanders, in Belgium, in the Flemish part of the country, have to follow a 1-year course, 100 hours of course, and I think 20 hours of practical exercising with role playings, speaking with children. And there is also a kind of a paper we have to write at the end. And at this moment, in all this period, we have a formation of 1,000 youth lawyers on 10,000 normal lawyers, let's say, in Flanders. The judges have to follow, when they are sitting in family court and youth court, a 25 hours course also, but they agree that it's not enough, that they should like to have more courses and more exercise with role playings, etc. If there is interest, I can give the short content of our special course for youth lawyers that is written by the Flemish Bar Association for these lawyers, and I can tell you that we started in 2007 with people that contributed free, without fee or whatever, to make this course, and that were all professors in the universities or high schools or colleagues, lawyers or judges who did it together. So I think we should not wait till we can read special texts in the law or in the directives. We should try to gather people who think the same thing and to work together. It is a multidisciplinary course, and we work together with psychologists, with sociologues, with psychiatrists, of course, lawyers, and then policemen, to give this multidisciplinary course.
Yeah, I agree. Professional trainings are really important to our work and around the EU countries. So I can see now that we passed the time. I don't know if anyone else has any comment, final remark. I can see that Aisha is not able to express what she wanted to say, but then if there is no other comment or raised hand, I would like to thank you all for attending and for joining. Please, as my colleague shared in the chat, the survey, if you have time to complete it. Otherwise, I think we might have the opportunity to exchange again in this important matter during the lifetime of the project, because we'll have other webinar in the year. So I'm happy to you presenting, and thank you again for the speakers. And let's try to connect again. Thank you all. Have a nice evening. Bye.
Thank you. Bye.
Thank you. Bye.